You know, put on all my signs, listened by the Hutchinson team, sold by the Hutchinson team, or something like that. The question is, what hoops do I have to jump through to do that? And the answer, the good news is, you don't need the approval of the BRE anymore to do that. All you need is your broker's permission, obviously. But if you have your broker's permission, you don't have to file with the BRE as fictitious name, DBA. You can just do it. And that's good. Here's the bad thing. The rule says on any marketing materials with a team name, whatever size the name of the team is, whether for sale sign, a flyer, an ad, or something, the name of the brokerage has to be just as big. I don't see that, basically. I don't see that. I see the broker's name real small and the team name real big. Now, we're trying to get them to adjust that to make it a little more, you know, maybe half the size or something like that. But the point is, the way it stands right now, that's what it says, okay? One more new law related to that is, let's say you're just a salesperson, but you want to sort of do business under a fictitious name. You want to call yourself, you know, I don't know what you want to call yourself. Blonde realtor in Bakersfield or something like that. I mean, there are a lot of blondes in Bakersfield. Whatever. The point is, do you know, as of now, an agent can get a DBA? That was never true before. Of course, you need your broker's permission, obviously. But if you have your broker's permission, you can apply to a fictitious name as an agent. It used to be only a broker could do it or only a team can do it. Now, an individual salesperson, if you have your broker's permission, can apply to the BRE and be able to do business under a fictitious name. Now, the team name, you don't even need the BRE's permission anymore. As an individual salesperson, you would need to go through the process of filing with the BRE, but they could say no, in other words. Bottom line, you always need your broker's permission, of course, right? But that's sort of the change with that. All right, enough with the BRE. Next topic. A lot of issues with disclosures. There's some new laws and there's some changes on the forms that I want you to know about. First of all, let's talk about agency disclosure. Did you know that there's a new law effective, 2 weeks ago that says if you're doing commercial or land, the agency disclosure law now applies? For the last 30 years, you've only used the agency disclosure form if it's residential 1 to 4, sales or leases of more than a year. Now, if you sell or lease land or commercial, lease for more than a year or just a sale, you got to give the agency disclosure form to your seller and your buyer, and you have to do the agency confirmation on the commercial purchase contract and the vacant land purchase contract. Well, what if it's multi-use residential? You still don't have to do it. Isn't that weird? So if you do a commercial property, you got to do agency. If you do residential 1 to 4, but if you do a 5-unit residential, you don't have to. Go figure. I think the apartment buildings have a really good lobbyist, and they kept that out. So anyway, but that's, I think, really what happened. So that's the latest on agency. Now, you know the latest on the contract. You've noticed that the agency form is attached to the contract, right? That's a pretty big deal, isn't it? For the last 14 years, the only thing attached to the contract was the buyer inspection advisory. So for the last 14 years, if you either got a paper copy or you went to the zip form and you pulled up the RPA, what you got was the 8-page RPA plus the 2-page buyer inspection advisory. You know, if you go today, here's what you get. First, you get a table of contents. You can ignore that. Then you get the agency disclosure form. Then you get the other agency form, which is now called the PRBS. Then you get the 10-page contract. Then you get the 1-page buyer inspection advisory. So by the way, the BIA went from 2 pages to 1 when the purchase contract went from 8 to 10. So hopefully that's all working now. There were some bugs when it first started. But that's to remind you how important those agency forms are. It's also to remind you that they have to get signed before they sign the contract. But here are a couple things people don't know. First of all, you know in the agency disclosure form, you know there are 3 of them, right? The AD1, the AD2, the AD3. Which is the one that comes attached to the purchase contract? The AD2. What about the AD1? Well, that's the one the listing agent to seller, and that's the one you should have given your seller at the time you took the listing, right? If you haven't given an agency form to the seller by the time you're getting an offer, you're too late. Do you know that if you don't have the seller sign the agency before they sign the listing, you don't have a valid listing? Aren't you glad they don't know that, though? But anyway, try to remember that, okay? Before you take a listing, make them sign the agency disclosure form. Now, when you're a buyer's agent and you pull up zip form, you're going to see the AD2, which says at the top, selling agent to buyer. I think actually it's not a bad idea to give that to your buyer before you even write an offer, but at the very latest, at least it comes up automatically so it's not too late to have the buyer sign it. But then, of course, there's the AD3, which is the one that says at the top, selling agent to seller. The buyer's agent is supposed to give an agency to the seller. But I think you know this. You don't really need that form because the seller can also sign the bottom of the AD2. So you really just need the AD1, listing agent to seller. You give that to them at the time you take the listing. The AD2 is going to come attached to the offer. You, the buyer's agent, are obviously going to have your buyer sign it before they sign the offer. Then you're going to submit it with your offer, and then hopefully the listing agent will have the seller sign the same thing. What if the listing agent never makes the seller sign that and give it back to you? Well, you did the best you could. It's not your fault. You know, you tried. You attached it to the offer. You said, sign this. If they didn't sign it, they didn't sign it. It's not your fault. Okay? The other thing, the other agency form, did you catch that they changed the name? For the last 14 years, it was called the DA, and now it's called the PRBS. BS doesn't mean what you think it means, okay? It's just, why did they change the name? Because nobody knew what DA stood for. Let me ask you, what did DA stand for? District Attorney, good guess? No. Dual agency, no. Disclosure and authorization, nobody knew that. The point, and it was very confusing, DAAD, AD, you know, it'd be very confusing. So they just changed the name. It's the same form. It's now PRBS, potential representation of more than one buyer or seller. It's the form that gives you permission to be a dual agent. Well, what if your clients don't want to sign that form? What if they don't want to give you permission to be a dual agent? That's why I say you just give them the form and don't explain it. Just say, shut up and sign this. Well, what is it? It doesn't matter. Everyone signs it. Just sign it. That's my legal advice to you. Okay. But did you know the listing agent, you don't really need to worry about that. In other words, so when the buyer's agent pulls up the counter, they're going to get the PRBS. And you should have your buyer sign it. But you don't need to get the seller to sign it. You know why you don't? Because that language has been incorporated into the CAR listing form. So if you're all using the CAR listing form, which I think you're all using that rather than some other listing form, you've already got the PRBS signed. So what I'm saying is, in a normal transaction, don't kill yourself. Don't jeopardize the deal if it's an issue of getting the seller to sign the PRBS. Whether you're the buyer's agent or the seller's agent, it's not crucial that you get the seller to sign that. You can just sort of ignore it. Now, I know what you're saying. My broker says that they want that signed, and I'm not going to get paid a commission unless I get it signed in the file. Well, then do what your broker says. See, some of you are going to go back to your broker and say, Gov said I don't have to do this, and I'm always going to support your broker. I like brokers who want more than what's actually necessary. That's a sign of a good broker. That's a sign of a detail-oriented broker that's very conscious of being very careful and detailed. So I'm going to support that. I'm just saying, don't let the deal get killed because you can't get the seller to sign the PRBS, because technically they've already signed it. You don't really have to worry about it. Okay? Anything else? So that's enough with agents. Let's talk about other types of disclosures. Once again, if any of you do commercial no, not vacant land, just commercial. There was supposed to be a new law that was going to say that if you sell or lease commercial property over 5,000 square feet, you had to make this special energy use disclosure to the buyer. That has been postponed for 2 years. So next year I'll remind you to do it in 2016. But don't worry about right now selling or leasing commercial property with that new energy disclosure. You don't have to do it. What else is new with disclosure? The TDS, I think I mentioned this when I taught the class, just in case I didn't. Effective last July, there's a new question on the transfer disclosure statement. It's question 16 on the second page. I know what you're thinking. Well, the TDS on the seller's part, they're supposed to fill that out without my assistance. And that's true. You never want to help the seller fill out the TDS because then they accuse you of, I didn't mean to say that, my agent made me say that. Okay. But nevertheless, there's one question on the TDS now where your sellers might look at it and they say, I don't understand this question. And I don't blame them. You know what a question 16 says? It says, seller, are you aware of any section 900 or 903 claims for damages? Seller's going to say, section 900 of what? You know, they may not know what that, I wouldn't, if I wasn't a lawyer, I wouldn't know what that meant. So they may come to you and say, hey, listing agent of mine, I don't understand what they're asking me in question 16. So now I'm going to tell you what that means. That they're asking them, are you involved in a monetary dispute with a builder or contractor? So if you ever have a seller on your listing who says, I don't understand question 16 on the second page, what are they asking me? You tell them, are you involved in a monetary dispute? Are you trying to get the builder or contractor to fix something that they did wrong? That's what they're asking. If the answer is no, you put no. Okay? All right, last thing on disclosure. And this involves the new contract, but it's very important. Two things. First of all, I hope you've all noticed that the seller property questionnaire is now automatically mandatory, right? For the last 14 years, if you wanted the seller property questionnaire, you had to check a box. I want the SPQ. Otherwise, all the seller had to give you was the one-page supplemental disclosure, SSD. Now, the way the contract is written, the seller, that's not enough. The seller has to do the 4-page SPQ and deliver it to the buyer, unless the seller counters it out. So the way the contract is written, seller will do an SPQ. Okay? Remember, here's how I like to, and I know when I taught the class I said this, I'll say it again. When you think about disclosures, here's the way you should approach it. There are 5 things you got to think about. First, you order an NHD report. You all do that. Then there's 4 other things you have to think about. The TDS, right? The lead paint, the SPQ or the SSD, now it's SPQ, and 4th are the booklets, right? Those are the 4 things that the NHD company might not do for you. Some NHD companies do include the booklets, don't they? Like the environmental hazard, the earthquake booklet, the home energy rating system, but the NHD is never going to do the TDS for you. They're never going to do the SPQ for you, and they shouldn't be doing the lead paint form for you. They can do the lead paint booklet, but the form needs to be signed by the seller. Which leads me to my other topic. Okay. I know when I taught this class, to most of you, you heard this, but let me just reiterate because it's really important. When you have a buyer in a deal, the buyer has the right to get out of the deal, right? Certain circumstances. What gives the buyer the right to cancel? 2 things. They've got contingencies. Until you remove your contingencies, you can cancel. But did you know the buyer has a whole other way to get out of a deal? The buyer has a right of rescission, a 3-day right of rescission. What gives the buyer a 3-day right of rescission? 3 things. The TDS, the NHD report, and the lead paint form. Which means if I give the buyer a TDS, for the next 3 days they can walk away. They don't even need a reason. They can just walk. It doesn't matter about contingencies. If they've removed all their contingencies and I finally give them the TDS, they can still walk away. Or if they've removed all their contingencies and I give them the NHD report, they can still walk away. They've removed all the contingencies and I give them the lead paint form, they can walk away. Okay. You know that, probably, so that's why you give them these things up front, don't you? To get rid of those 3 days. Here's what the issues have been happening. One of them is, have you ever got a TDS from a seller and they don't answer all the questions? Do you know if you don't answer one question, it's not a complete TDS? You still have a 3-day right of rescission? So here's what a smart buyer does. You give them a TDS and the seller didn't answer one of the questions. The buyer just holds it. Doesn't tell anybody. Then they remove all their contingencies, but that buyer knows I can still get out of this deal anytime I want, right up until it closes, because I never got a complete TDS. So that's one thing to think about. Second thing is, you ever have a TDS where the listing agent checks the box and says, see attached AVID, and then they don't attach the AVID? And they don't send that till later? Do you know until they send the AVID, there's not a complete TDS and the buyer still has a 3-day right of rescission? Important to know. But here's the other thing. What about the buyer's agent? Do you know some buyer's agents deliberately delay doing their AVID because they think that's in their buyer's interest? Because what they do is they say, well, so on the TDS, the buyer's agent signs it and says, see attached AVID. But then they don't do the AVID right away because they think, well, the longer I delay doing my AVID, the longer I'm extending my client's right of rescission. And that's a good thing, to keep my client's options open. So they deliberately delay it. This is what's changed. The purchase contract now says that the buyer and seller agree that all disclosures are complete once they are signed by the seller and the listing agent. The buyer's agent doesn't need to sign anything to make it official. This takes away the incentive for the buyer's agent to delay doing things. Some buyer's agents, actually good agents, would deliberately delay signing a disclosure thinking that extends their client's right of rescission. Like they deliberately don't sign the NHD report, or they deliberately don't sign the TDS. They're trying to preserve, well, you can't do that anymore. There's no sense in doing that anymore. So here's what I'm really telling you. When you're the listing agent and you deliver the NHD or the lead paint or the TDS to the buyer's agent, as soon as you receive it, that's when the 3-day clock begins. Doesn't matter when you sign it. You don't even have to sign them anymore. You got to give them to your client, of course, but whether you give it to your client today or tomorrow or the next day, as soon as you received it, the 3 days begins. So moral of the story, buyer's agents don't delay. When you get a disclosure from the listing agent, you immediately give it to the buyer. Yes, you still have to do a visual inspection. Yes, you still have to fill out an avid. If you don't do that, you know what you are? You're committing negligence. But it doesn't affect the 3-day right of rescission. Okay? You can understand that fundamental distinction. Now let me get back to the other thing. Maybe the NHD report. When you guys order an NHD report, is it usually ordered by escrow? Or does the listing agent order it? Sometimes both. Okay. Let's say escrow orders the NHD report. Is it then sent to escrow and escrow sends it to all the individual agents, or does the NHD company send it directly to the agents? Here's what I'm getting at. Remember what I just said? The NHD report is not complete unless it is signed by the seller and the listing agent. So what I see sometimes happening is the natural hazard disclosure report gets ordered, and then they send one copy to everybody. But it goes directly to the buyer's agent, but it's not signed by the seller and the listing agent. Do you know if it's not signed by the seller and listing agent, it's not complete? And the buyer still has a 3-day right of rescission, which means they can walk away from the deal right up until the day of closing. You don't want that. So to summarize, listing agents, make sure the NHD report is signed by the seller and the listing agent. Make sure the TDS is signed by the seller and listing agent. And if there's an avid there, make sure you include the avid with the TDS right up front. And make sure your seller answers all the questions. What if the seller says, I don't know the answer to all these questions? Well, then put no. No is I don't know. The questions are all, are you aware? I don't know. Well, that's a no. You're not aware. You're not saying it's not true. You're just saying as far as you know, it's not true. Some sellers I know are reluctant to answer those questions because they say, I don't know the answer. That's a perfectly legitimate answer. Put no. Okay? We've seen a lot of cases on this recently, and the form has changed, and I just want you to be updated on all that. One more disclosure issue. Do you know that some sellers are exempt from disclosures? Who's exempt? REOs are exempt. Probates are exempt. Bankruptcy sales and trusts. Are all trusts exempt? Well, who's not exempt? Do you know you're not exempt if it's a living trust and there's a sole trustee and that trustee has ever been on title or has lived there in the last 12 months? But only if it's a sole trustee. So if it's a husband and wife, joint trustees, even though they've lived there for the last 20 years, and they've been on title for 20 years up until a month ago, they're exempt. But if it's a sole trustee, they're not exempt. But guess what? Let's say you are a joint trustee and you're exempt from the form. Since you lived there the last 20 years, don't you know everything about the house? Yes. That means you have to disclose everything to the buyer. You just don't have to use the forms. So you don't have to do the TDS and the SPQ, but all those questions on that form, if you know the answer to them, you're supposed to be telling that to the buyer. So I almost think you might as well use the form. It's the easiest way to make the disclosure that you have to make anyway. You're exempt from the form. You're never exempt from disclosing what you know. On the other hand, sometimes you have a seller who's not exempt, but they don't know anything about the property, like an absentee seller. They've rented it out for 10 years. They know nothing about this house, and now they're selling it. Are they exempt from the TDS and the SPQ? No. Do they know the answers to any of those questions? No. It's perfectly legitimate to say, I don't know on every single one. But you're not exempt from doing it. Whereas some people are exempt from doing it, but they know the answers to all those questions, so they should answer all the questions. These are the issues we keep seeing time and time again. Any questions on any of that? Yeah. And never been on title. Well, so in your question, the sole trustee has never been there, so they're exempt. And plus, they've never been there, so they don't know anything about the property. So they're really exempt. Yeah, sole trustee who's never been on title. Exactly. Everything I say for the TDS is also true for the SBQ. If you're exempt from one, you're exempt from the other. Yeah. Yeah. And you're also exempt from the booklets, too, except the lead paint. If it's pre-78 property, nobody's exempt from the lead paint form and the lead paint booklet. If you're exempt from the TDS, you're exempt from the SBQ, and you're also exempt from all the other booklets. But if it's pre-78, no one's exempt from that. One more thing I forgot to mention. On those booklets, we agreed that some of you agree with me that the NHD company sometimes provides the booklets. What are the booklets? Homeowner's Guide to Earthquake Safety, Environmental Hazards, Home Energy Rating System, and lead paint. Does the seller have to sign those booklets? No. With one exception. If the house is pre-1960, the seller does have to sign the Homeowner's Guide to Earthquake Safety. So, to summarize, NHD report signed by seller and listing agent. TDS signed by seller and listing agent. Lead paint form signed by seller. Booklets signed by nobody except for the earthquake booklet on a pre-1960. And of course, the buyer has to sign everything. The contract says buyer agrees to sign and return all disclosures. So the buyer always has to sign. It's just the buyer's agent doesn't have to sign anymore. But you have two jobs, though. Make sure that the disclosures are delivered to the buyer and do a visual inspection and disclose in writing everything that you know or see. And I would recommend using an Avid for that. Wouldn't that be nice? The problem is the answer is no. The TDS is not a CAR form. It's a government form. It takes an act of the legislature to change it. It's so difficult to do that. So we try, but we can't just change the words. Wouldn't it be nice if it actually said, seller, are you involved in a monetary dispute with a builder or contractor? Wouldn't that be helpful? We can't just change that. All you got to do is remember what I said. Yeah. Yeah, that's such a good question. People ask me all the time, what exactly am I supposed to be putting on the Avid? Am I supposed to be describing the property? No. Am I supposed to be saying what features it has? No, that's for the flyer. So what's the purpose of the Avid? The Avid is like you said, to disclose negative things. But it's not to disclose defects. You know whose job it is to discover defects? The inspector. What's the realtor's job? What are you supposed to be disclosing? Visual red flags. A home inspector is supposed to say, you have a water leak. The realtor is supposed to say, there's a stain on the ceiling that's not normally there. I don't know what that means, but there's a stain on the ceiling. The floor in the family room is uneven. I don't know if there's any settling or soil problem. All I can tell you is the floor is uneven. You're supposed to identify things that aren't right. On the outside, too. The gutters, I've seen a lot of houses. I've seen a lot of gutters. That gutter doesn't look like it's supposed to look. I've seen a lot of stucco walls. They all have cracks in them. This has more cracks than normal. I mean, shouldn't buyers be able to notice all that stuff, too? Why do we even need a realtor? Because buyers, here's the difference between you and a buyer. One of many differences is you in your life have seen a lot of houses. You know basically how it's supposed to look. The buyer may have only looked closely at 2 houses in their whole life, the 2 houses that they've lived in. Do you know if you work long enough in Bakersfield, you'll probably set foot in every single house in Bakersfield? Think about that. If you've been here in the business 30 years, eventually everything will be on sale, and you'll be in their house. You will be in every house in Bakersfield. And you've seen enough houses, so you sort of know what it's supposed to look like. The whole idea of a realtor on a visual inspection is to disclose red flags, potential indicators of problems. Might not be a problem. Now, what I say on the Avid, though, is as you go through each room, if there's nothing in this room, you say nothing to disclose. Don't just leave it blank, because then they say, hey, you skipped that room. You know what I mean? And it doesn't hurt to be nitpicky, because God forbid you ever get sued. It'll be a disclosure case, and the Avid will be Exhibit 1. It'll be on a movie screen in the courtroom, and the jury will be staring at your Avid for hours. They're going to be critiquing your handwriting. They're going to be critiquing your grammar. And they like to see, oh, look how diligent she is. She pointed out all these little things. So it doesn't hurt to come up with little things. But it's really not supposed to be where you describe, hey, it's got new drapes and new car. You know, that's technically not what we're supposed to do. Yeah. Listing agent and seller. Right. Even though it says agent, which makes it very obvious that doesn't that mean both agents are supposed to sign? Number one, the law says the buyer's agent doesn't sign. Number two, the purchase contract now says buyer and seller agree that buyer's agent signature. So if your broker wants it signed, do what your broker says. I don't care. I'm just saying, as far as the 3-day right of rescission, which is triggered by the form being complete, it's complete when it's signed by the seller and the listing agent and delivered to the buyer's agent. What if you deliver it to the buyer's agent on Monday and they don't deliver it to the buyer till Tuesday? Well, you know, the 3-day right of rescission began on Monday when the agent got it, not when the buyer got it. So everything that gets delivered to you, you have to instantly give it to your buyer, because the clock is running as soon as they get it, as soon as you get it. Okay? Yeah. Right. That is such a good question, and I'll repeat his question, and I was actually going to talk about his question because there was a recent case that finally answered his question. Here's his question: you're the listing agent, and you notice that your seller said something on the TDS that was incorrect. Do you have a legal obligation to correct that? Can you get sued because your client wrote something that was not true? Here's what the court said. The court said, if by just looking at it, first of all, listing agent, you do have to look at what the seller said. You can't just ignore. You have to look at what your client said. And if something your client said is clearly wrong, you have to correct it. Meaning you either have to go to your client and say, that's not really true, is it? You better change that. What if your client says, no, that's what I'm going with, and you know it's not true? Then you got to actually put on your part of the TDS, my client is wrong. My client is lying to you. That's not really true. Of course, you're not going to want to do that. Your other choice is cancel your relationship with your client. So yeah, you do have an obligation to read what your seller wrote, and if it's obviously true, you have to contradict. But here's what the court said. But, listen very carefully, listing agent, you have no obligation to investigate to verify the truth of what the seller wrote. Only things that are obvious to you already know. Based on your current knowledge, you know that's not true. But if you look at something the seller says, I don't know if that's true or not, I'd have to do a little investigation to know. You don't have to do any investigation. So that's a fine line, I know. You have to correct your seller, but you don't have to, only based on your knowledge that you already have. If it requires, you don't have to go hire a private investigator to investigate everything the seller said to make sure it's true. Just what you basically already know. So in other words, the realtor is too lazy to sign things, so he has his assistant just stamp. That's probably okay. I've never seen that become an issue where that was considered not valid. So of course the agent can't say, well, that wasn't me, it was just a stamp. No, if you authorize someone to stamp, that's you. So yeah, stamps are okay. Yeah. That's a good question. What if you're on the buyer's side and something comes in on disclosure that's not true? Well, you could sue the seller for misrepresentation is what you could do. I mean, in other words, you don't have an obligation to make, you don't go call up the seller and say, you said something wrong, you better change it. Well, you know they said something wrong. You happen to notice the dogs yourself. Don't tell them, just sue them. I mean, that's what a lawyer says, right? I mean, the point is, all you're going to do is you're going to point out to your client, did you see those dogs? I saw those dogs. I guess they're not telling the truth. But you don't have any obligation to go make them change the form. Right. Right. Sure. Yes, you can just put it on the form yourself. Yes, you can put on the avid yourself. Just recommending a home inspection doesn't solve the problem. You still have an obligation to tell the buyer that what my client said there is not true. I think it's obviously better if you can get your client to change their mind, so it doesn't make your client look bad. But if your client absolutely says, no, that's what I'm going to say, and you know it's not true, yeah, you do have some obligation. That doesn't solve that problem. And yeah, I mean, I know agents someday, every single disclosure they write, recommend a home inspection. Personally, I wouldn't even do that, because I've seen in the courtroom the plaintiff's attorneys say, look at this realtor, they're trying to pass the buck to somebody else. Now, that's not what you're doing, but you don't need to do this. Plus, the purchase contract says about 3 different places it is recommended strongly that buyer gets an inspection. You don't have to say it again. You're already on the record that they've got to do it. So I don't see any benefit from doing that. You know, that's a good question. This DocuSign, believe it or not, the technology is so new relatively that there haven't been cases on that yet. I don't want you to be the test case on that, so I would do whatever I could to make sure it's not cut off. And if it is, does that invalidate the whole contract? I hope not. There's going to be a test case on that. Try to avoid being that, you know, because, well, DocuSign is a very good product because we have a relationship with them, so it's got to be a good product. Plus there's Digital Ink, which is free, but, you know, they're all good. I have no comment. Yes. Someone had a hand up there? Yeah. Natural hazard disclosure report? It does, yeah. Well, if it's you said, can I give them a master NHD or I have to give them an individual NHD? The point is you have to tell them in writing whether they're in an earthquake zone, a flood zone, or a fire zone. If the master NHD accomplishes that, and it tells them if they're in, most of us now want the NHD with the tax reports also, right? If all that's on the NHD report, it doesn't matter if it's a master one or individual one. The point is to give the information to the buyer. That's all you need to do. Okay, let me do some more stuff. I'll have time for questions at the end. I just want to keep going a little bit. So I've finished up Bureau of Real Estate and disclosures. Next topic, landlord-tenant. Are any of you in property management? Do any of you have your own rental property? Do you want to know what's new in rentals? Nothing is new. Isn't that good? There's only one important thing to tell you about. You ready for this? If you have an apartment building with at least 5 parking spaces, or a commercial building with at least 50 parking spaces, if one of the tenants has an electric vehicle, you have to allow them to build an electric vehicle charging station. But they have to pay every single cent of that, including the extra electricity and all that stuff. So they got to build it, get insurance for it, build the infrastructure, remove it when they leave. But you cannot stop them from doing it, which really means you got to assign them a parking space, right? You got to say, this is your parking space because you built the electric charging station for that. Only if there's at least 5 on residential, at least 50 parking spaces on commercial. And that's really the only thing new on rentals, okay? Next topic, employer-employee relations. Some of you are employers. I mean, if you're a broker and you have agents, they're not employees, but you may have other employees, or some of you may have assistants. who are in a employer-employee relationship with you. By the way, when you do have a personal assistant, is that person generally considered an employee or an independent contractor? It depends on what they're doing. If they're doing licensed work, they're probably considered an independent contractor. But if they're doing unlicensed work, even if they have a license, they're your employee. You know what's changed with employer-employee law? Two things. First of all, the minimum wage went up. And I know you're only paying them the lowest you can possibly pay them, so that's important to know. And effective July 1st of this year, coming up, every employee in California is entitled to paid sick leave. But how does that work? Well, it accumulates kind of slowly. So starting July 1st, if you're an employee, for every 30 days you work, 30 full days, you accumulate 1 hour of paid sick time. So let's say you got an employee, and you don't have to start giving it until 3 months after that, which would probably, for a full-time employee, that would be, October 1st. But let's say you've got an employee who has a part-time employee. Once they accumulate that number of hours, they're supposed to work for you this afternoon, and they call in sick. I'm sick. Well, you got to, depending on how many hours they've accumulated, you have to pay them for the hours that they're sick. Okay? Part-time, full-time employees are entitled to paid sick leave in California starting July 1st. Okay? Question? You're right. I'm sorry, 30 hours, not 30 days. That'd be really slow if it was 30 days. Yeah. That would take a long time. But here's the good news. You can cap it at 24 hours a year. No matter how much they work, you can cap you don't have to give them more than 24 hours of sick leave a year, no matter how many hours they work. Okay? So that's good. Next topic, homeowner associations. What's new? Do you know we're in a drought? Have you heard? So what is the significance of that? Significance of that is HOAs may no longer enforce rules that prohibit owners from changing their vegetation to low water use plants. In other words, they can't necessarily dictate to you, well, you have to have this type of grass and this type of plants. Anything that says that in the CC&Rs is unenforceable now. They cannot stop you from changing out the vegetation you have under the CC&Rs to make them low water usage. In addition, they cannot fine you for not watering your lawn. You could let your grass die if you want. It can be just brown and ugly because you don't want to pay for it. And you, pardon? Has to be what? Yeah, you do have to cut the grass. Yes, you have to cut the grass. You just don't have to water it. Unless the association provides recycled water. Then you have to water your grass. Yes. Yeah, I mean, there's nothing new with that. So if the tenant agrees that they're going to pay for the water, that can still be enforceable. Yeah, I'm just talking about HOAs. Okay? They may change that, but for now, yes, tenants can be required to pay for the water. Yes? That's the question I'm trying to get the answer to myself. In other words, what if the CC&Rs, are you violating the CC&Rs if you want to just put in artificial turf or rocks? I read it that that's okay, but I can't guarantee that. We're trying to get clarifying amendments to really make it clear that you can really rip up your grass. What I'm worried about is, does that only last for the length of the drought? 3 years from now, the governor declares we're no longer in a drought. Now the HOA comes back, says rip up your artificial turf and put the real grass back in. So this is another issue, which is why we're really trying to get that clarified. It's a very good question. Here's the big news on HOAs, though, and that is the whole charging for the documentation. Do you ever get the sense that HOAs are gouging you? Yeah. I mean, first of all, they want the money up front, right? Because most other people wait until title company gets paid out of proceeds, right? Doesn't the NHG company usually get paid at the end? I mean, the only people that want the money right up front is usually the HOA, right? Okay. So that's one issue. The other issue is they seem to demand too much money. I mean, the law says to provide these documents, the HOA is only supposed to charge you what it actually costs them to produce it. So how much can it possibly cost to email you the CC&Rs or post it on a website or even Xerox it and mail it to you? How could that possibly cost more than 20 bucks? But they charge you like $500 or something. How do they get away with that? Well, up until now, the way they've gotten away with it is by bundling together with the mandatory disclosures, which are the CC&Rs, the articles, the bylaws, the reserve study, the budget, by bundling with that other stuff. The other stuff they can charge you whatever they want for. So they basically say, if you want the mandatory stuff, you got to get the whole package. That's the only way you're going to get it, and we're going to charge you $500 for the whole package. Here's what changed 2 weeks ago. 2 weeks ago, the law now says, listing, if you, let's say you list a condo, and you put a request into the HOA to provide the documents. Basically, the HOA has to respond by dividing mandatory from non-mandatory. And in other words, before they even charge you, they're supposed to tell you how much they're going to charge you. They're going to give you a list of the mandatory ones, the ones I mentioned, and say this is how much we're going to charge you for those, and that can only has to be their actual cost. So they should be sending you a form that says CC&Rs $2, bylaws $3, reserve study $4. I mean, how much can it cost to Xerox and send that to you? Then the other stuff, of course, your buyer may want the other stuff, the minutes for the last 12 months and stuff like that, but they can charge you whatever they want for that. So maybe this isn't going to solve the problem. But what might happen is, I think when you see how much they're charging you for the other stuff, all of a sudden your clients aren't going to want that so much. Maybe I don't need the minutes for the last 12 months for $500. You know, maybe I'll just take the reserve study and the budget. And I mean, another thing that's not mandatory that they can charge you for is the annual report. Now that's kind of a good thing. But the point is, anyway, this should start happening to you. You should be getting 2 different forms from the HOA, mandatory and non-mandatory. And CAR has created 2 forms for this. I mean, they're not forms you have to use, but maybe when you list a condo, you download the HOA 2 and the HOA 3, give them to the association, or give it to escrow to give to the association, to basically educate the HOA on what they're supposed to do. Because remember, up to now we had one form called HOA, Homeowner Association Information Request, and that was a 2-page form. Page 1 was basically, we're requesting the information, and page 2 was listing all the documents. Now there's HOA 1 is the request, HOA 2 is the list of mandatory, HOA 3 is the list of non-mandatory. We hope the HOAs will do what they're supposed to do. There's no guarantee. If they don't do it, all you can do is sue them. Nobody wants to sue them, but that is a change, okay? Yeah. Yeah, remember when I said about the right of rescission, that's only triggered by 3 things: TDS, lead paint form, and the NHD report. So if the HOA documents are late, that doesn't give the buyer a 3-day right of rescission. What it does, though, it gives the buyer an extension of their duty to remove the contingency. So it does extend their rights, but by 5 days. In other words, the contract says buyers have to remove contingencies in 17 days. Or they got to remove it 5 days after they receive the documentation that the contingency is referring to. In other words, if you don't get the prelim until day 19, you don't have to remove that contingency until day 24. If you don't get the CC&Rs until day 26, you don't have to remove it till day 31. That's why I always tell buyers agents, it's part of your job to keep track of, when did I get that NHD report? When did I get those CC&Rs? When did I get that prelim? Because your buyer's deadline to remove contingencies might be extended by the fact that those documents come in late. It's very complicated. You got to keep track of, for contingencies, you also have to keep track of it for the 3-day right of rescission. But that's your job as a buyer's agent, to keep track of how long does your buyer have to get out of the deal. Okay? Yeah. Yes, it does. Good luck getting them to comply with the law, but yes, it does apply to out-of-state HOAs. I mean, this may all be fruitless. They're going to do what they want to do, and nobody wants to go to the trouble of suing them, but theoretically, these are the changes with the HOA now. Now, one other thing. Have you noticed on the contract it now says it's not negotiable. Seller must pay for the mandatory disclosures. You've always checked the box seller to pay anyway, right? Haven't you normally? Well, now if you notice there's no box to check, it just says seller will pay. That's not a big deal. The other thing is when you list a condo and the HOA wants the money up front, where does that money usually come from? Does escrow send the money to the HOA or does the seller do it directly? So I'm hearing both. The agent is even worse, right? That's even worse. First of all, did you notice I mentioned this when I taught the class, that the contract now says that if escrow is going to front the money to the HOA, the seller has to put money into escrow. This is the first time in 100 years that the purchase contract has actually said the seller has to deposit money into escrow up front to pay the cost of ordering the HOA documents up front. I think it's a better idea just to have the seller pay the HOA directly with a credit card. Then you avoid the whole escrow issue. But nevertheless, if you're in a situation where the escrow is going to use escrow funds to pay the HOA, then the seller should be putting the money in. Okay? Yes. What do you mean? Well, that's the whole point of what you're not supposed to do, because the earnest money deposit is the buyer's money, and the law says the seller has to pay. So that's the whole reason we changed the contract, because it wouldn't be right to use the buyer's earnest money deposit money to pay for the HOA fees. So the seller should put the money in. Yeah. Remember what I always say, if you're doing REO, forget everything I say, because they're going to do whatever they want to do, and their contract is different than our contract, and they ignore the law anyway, so do what you got to do. Yeah, unfortunately, do what you got to do. All right, next topic, and I'm almost done. Taxes. I actually have good news on taxes. Yeah, that's it. All taxes have been totally abolished at all times. That's the good news. Yeah. Okay, not quite that good. But distressed properties, short sales. To give you the history of this, if you don't want to focus on these details, just don't pay attention for the next minute or two, and then I'll give you the bottom line at the end. But prior to 2007, if you did a short sale or a loan modification with a principal reduction, that means the lender is forgiving part of the debt, and you had to pay income tax on that. In 2007, there was a federal law that says, guess what? If it's residential 1 to 4, you don't have to pay income tax on debt forgiveness on a short sale or a loan mod. Then in 2009, California said, we're going to do it in California too. So in 2009, 10, 11, and 12, you didn't have to pay state or federal income tax on the debt forgiveness on a short sale or a loan mod. But then the California law expired at the end of 2012. The federal law went all the way to the end of 2013. So if you did a short sale or a loan modification that closed in 2012, you had to pay state income tax on the debt forgiveness. There's a new law that got passed that retroactively extended that to the end of 2013. So if any of you had a client, think back, that did a short sale or a loan mod in 2012, you can call them up with the good news that, hey, if you paid California any income tax on that transaction, you are now eligible for a refund. So that's good news. Well, what about short sales and loan mods that took place starting January 1st, 2014? You're still good, but there's some limitations. First of all, it doesn't apply to loan modifications anymore. So if you do a loan modification with a principal reduction starting in 2014, you're going to have to pay income tax on the amount of principal reduced. And also, the short sale thing doesn't apply to investors anymore. So the only time you get a break on, actually it only did for about 1 year anyway. So in other words, to avoid paying tax on a short sale, the question is the original loan that was the subject of the short sale, was it a purchase money residential loan at the time they took out the loan? In other words, was the money used to buy a house I'm going to live in? Now, they don't have to still be living in it now, and they could have refinanced it 3 times. They're still okay, as long as when they originally borrowed the money, that money was used to buy a house or build a house that they were going to live in as their primary residence. That was 10 years ago, and they're doing a short sale today. They don't have to pay income tax on the debt forgiveness. This is complicated stuff. You're not supposed to give tax advice. I just want you to know the bottom line. You can still avoid the tax, and if you closed a short sale in 2012, you may have some money coming back to you. So it's a good thing to tell your clients that. Makes you look very good if you do that. Okay? All right. What else is going on? Speaking of short sales, are you doing any more short sales? Are they still happening? Okay. Are you ever running into the mandatory auction process? Well, there's a new law that took effect 2 weeks ago that said, number one, these auction companies may no longer shift any liability to the listing agent or the seller. That was the worst thing. They said, you got to do an auction, and if we screw up, it's on you. That was nice, wasn't it? Well, that's gone. Plus, have you ever heard of a shill bid? That's when you're in an auction and someone makes a bid, but it's actually the seller who's making the bid. Don't you hate that? Well, at least we tried to get those prohibited, but the best we could do is they have to disclose it. As soon as when the bid comes in, and by the way, this is a bid from the seller. Oh, thanks for telling me. You know what I mean? They still can do shill bids, but they have to tell you. All right, what else is going on? That's really all the new, I'm almost done. That's really all the new laws I really think worth mentioning. If you want to see all the new laws, just go to car.org, go to the legal section, there's a tab, 2015 new laws. If you want my summary of all these laws, sort of the way I'm explaining to you today, look for my risk management report. I just posted it yesterday. Same place, car.org. Go to legal. If you can't find it, just call the hotline. Call me, email me, govh@car.org. I'll send you the link. I'll send it to you. It summarizes all the new laws, plus the cases. Any other cases worth mentioning? I mentioned the important case about you don't have to verify, investigate the truth of what the seller wrote on the TDS. Two other cases worth mentioning. One of them says, good news, appraisals do not have to be disclosed. We get asked that every now and then. Do I have to disclose to the second buyer what the first buyer's appraisal was when their deal fell apart? The answer is no. An appraisal is not a material fact. An appraisal is not a report that you have to disclose. An appraisal is someone's opinion. Everyone's entitled to an opinion. You don't have to disclose it to anybody. Unless it's FHA, of course, but they go with the property. But other than that, you don't have to disclose appraisals. This came out of this great case. It's so funny, where the buyer sued the lender, saying, you never should have lent me that money. You should have known. In other words, they blamed the lender for having an inflated appraisal. It says, you never should have, if you'd appraised it what it really was, you never would have given me the money. You never should have given me this money. The court basically laughed at them. And in the course of that, the court did say also, by the way, appraisals don't have to be disclosed. So you're asked point blank, was there a recent appraisal done on this property? Do you have to answer it? The answer is no. Now, if it's your own client, of course, your own client, you got to tell your own client everything. But if it's the other side, you don't have to tell them anything. You can't lie to them, but you don't have to. It's just not a fact that you have to disclose. See, that's a whole different thing. I'm distinguishing appraisals from inspections. So in other words, you're in a deal, you have buyer number one, buyer gets an inspection, buyer gives the seller the inspection, buyer number one backs out, goes away. Now you put it back on the market, buyer number two. Yes, you should give buyer number two, buyer number one's inspection reports. My point is you don't have to give them the earlier appraisals. The appraisals is not considered a material fact. Okay? Interesting, right? All right, my very last thing to wrap up, I'm going to do, yeah, I'm sorry. Yes. Your no tax if the original loan was a purchase money loan on residential 1 to 4. And you're even okay if you refinanced. But if you refinanced and took cash out for something other than buying real estate, in other words, even if you took it out for a home improvement, that's not good enough anymore. You may have to pay some tax on that. So the good news is, if it's a purchase money loan, state and federal, and by the way, that's only true in California. There's a special rule for California. It's a complicated story, but it's good news. On the short sale debt forgiveness, yes, residential 1 to 4. I know, home inspectors like to tell you that. It doesn't matter. In other words, even if the fact that your home inspector got you to sign something that says you're not going to share this information does not supersede the courts that have said over and over again, you have to disclose to buyer number 2 anything you learned about this property through an earlier inspection. In other words, the home inspector, they don't have the right to copyright or trademark that information. They can get you to sign something, but that doesn't supersede both the purchase contract and the court cases that said you have to disclose to the next buyer what you found out. Can who sell it? That's a concept right there. I'm going to give you this information only if you pay it to me. Yeah, I know. No, I understand. No, you got to disclose it whether they pay for it or not. It's a pretty good idea to get them to pay for it, but you got to give it to them whether they pay for it or not. Yeah. Yes. I think she has a real case, don't you?
Yeah.
This is not a hypothetical question here.
One of the heirs to the trust, the children,
Yes.
has lived in the home.
I don't care. All I care about is the trustee.
Okay, because in that 3-year period, how does the trustee know?
Right.
If there were dogs in the
Right.
house or on property
Right.
or
They don't know.
whatever.
They say they don't know.
No obligation to talk to
Exactly. No obligation to talk to the heir who happens to have lived there. Oh, goodness. There's a law on that, which I have not memorized. It's pretty much that they can't put much restriction on it. You pretty much they have to allow you to put the solar panels in the most effective site. They can put reasonable restrictions as long as it doesn't impact the effectiveness of. I'd have to look up the details, call the hotline, call me, but my memory is that's the general idea. They can't put restrictions on it that are going to interfere with the optimal use of it. And they obviously can't restrict them completely. But they can put reasonable, probable restrictions as long as it doesn't affect the efficiency. That's my memory. My memory is faulty, as you realize when you've been doing things for a long time, but that's my first gut reaction. Yeah. Yeah. Uh-oh. I don't think I would have said that, because I knew that form was going away. No, that wasn't me. I am pretty sure I did not say that the wood pest addendum was still going to be there. That's probably that person. I mean, I did say you could Xerox 1 million copies of the old wood pest addendum, and still use them. Why would you want to? Yeah, but and you can write it in. You can always write into an offer today. Other terms and conditions. Seller will provide a Section 1 termite clearance, blah, blah, blah. You just can't use a form anymore. Yeah. Right, it does. Whether they cancel or not, it just says, yeah. Right. Right, right. And I think the issue is, do they also have to physically give them the first buyer's inspection report, or just the information that they learned? Well, obviously just the information they learned, but the safest way, I think, to do that is to give them the actual, so the second buyer can't say, well, you just picked certain things, you didn't tell me the whole story. Yes. Are we talking about when there's a new buyer coming along? Well, if you never got it, you never got it. Well, see, that's a different question. You never got the first buyer's termite report, but the first buyer told you, I got a report that says there's $1,500 worth of damage. You better tell them that. And by the way, termite reports is a special rule, because termite reports are public record. You can always get those. Yes? Right. So they're going to have a tax on the principal reduction. That's considered debt forgiveness. Yes. Welcome. Yeah. Right. 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 That's like the oldest question in real estate, by the way. Yeah. You understand her question, right? Buyer number one is not performing. Seller has the right to cancel. Seller does all the right paperwork, demand to close, waits 3 days, gives them the cancellation. The buyer won't sign. Now you want to sell to someone else. Can you sell to someone else? That's the question. And as I always explain this, when the buyer doesn't perform, you give them the form, you can cancel the contract without their signature. But to cancel the escrow, you need their signature or a court order. The question is, can you sell and close with buyer number two without that cancellation? And the answer is, it depends. And I say that seriously. What it means is you're going to talk to the title company who's working on deal number two. And if the title company says, we're not closing this particular deal unless we get a cancellation from buyer number one, then you need a cancellation or a court order. And by the way, you can go to small claims court. Take at least a month, but you can get a court order canceling through small claims court. But I have done deals myself where I've closed the second one without that cancellation on the first one. You work with the title company, they analyze the situation, how out of contract that first buyer. Because what they're worried about is buyer number one filing a lawsuit and putting a list pendants on the property and putting a cloud on title. Yeah. All I can tell you is, obviously, have your seller get legal advice. You can file a small claims court action, and you can open the second escrow contingent on canceling the first one and talk to the title company and say, is this going to work or is it not going to work? Generally, no, unfortunately. Okay? Good question. That's the fundamental question in real estate. Sign as the acceptance, sign as the buyers. Yeah. The question is the trustee. The trustee is the simple answer. You got to look at the trust document. The trust agreement itself may say whether both signatures are required or not. The question was, you got more than one trustee or an irrevocable or revocable trust. What determines who has to sign things? And the answer is generally the trust document itself. So you got to look at that. And you remember, of course, that there's something new on the contract this year that says if you are signing on behalf of a trust or on behalf of a corporation or on behalf of a partnership, you have to attach to your offer or your acceptance that form, right? The representative capacity signature disclosure form, which basically says, I swear to God, I really am the trustee for this trust. And every time you see my name anywhere in the paperwork, that means the trust. And within 3 days after that, you have to provide proof to the other side, meaning the trust document that shows you really have the authority to sign. So now we're getting back to the exemption question, right? And remember what I said? If you're only exempt, I mean, your trusts are always exempt unless it's a sole trustee and the sole trust out of a revocable trust, and the trustee has either, that one person has either been on title or lived there in the last 12 months. All other trusts are exempt, But remember, I said, but if the trustees have lived there for 20 years, they're certainly not exempt from disclosing the facts. They just don't have to use the form. Gets complicated. Yes? No, just the part of the trust that says that I have the authority to sign. Yeah. Good question. The question is, you're selling a condo and you know your HOA is involved in a lawsuit. Is that question 16 on the TDS? No. But if you happen to know that your HOA is in a lawsuit, that's a material fact that you're going to disclose to the buyer. Yes? No, the debt forgiveness is forever now, until they change it. But I mean, it doesn't have a cutoff date. It's indefinitely in California now. Yes? I don't know what you mean by prospective buyers. I mean, all buyers are entitled to NHD disclosure. It means when you're in contract, not when you're a prospective buyer, meaning you're not in contract yet, right? You don't have to give it to those people. You can if you want to. You don't have to. But it doesn't mean buyers who aren't, or just looking about it. By the way, this is, you know what they do in Northern California now? Especially in the Bay Area, they put together a disclosure package, which includes the NHD and the TDS and the SBQ and all this stuff, and they hand it out at open houses and say, sign all this before you, if you want the house, if you want us to even look at your offer, sign all these and give them back before you submit your offer. That gets rid of the whole 3-day right of rescission, and makes, because you don't even get a 3-day right of rescission if you sign it before you sign the offer. You don't even get 3 days. But there's no requirement to give it to prospective buyers. No.
What if there is a class action between the son of the homeowner?
Very good question. Yeah, right. There's a development that all these homes were built by the same builder at the same time. Several of the of the homeowners in this development are involved, whether it's an HOA or not. The point is, a group of homeowners are involved in a class action against the builder, alleging, I'm sure, some type of construction defect. Your client lives in that development, same house built by the same builder, doesn't have the problem, right? So your question is, do I have to disclose the existence of this class action to my buyer? If it's an HOA, yes. Then the answer is really no. You really don't, because there could be nothing wrong with this house. Just because there's wrong with something else, it doesn't automatically mean there's something wrong with this house. Of course, if I were the buyer's agent and I knew about it, I would tell my client. Because remember, your fiduciary duty to your client goes above and beyond disclosing material facts. That's the listing agent's duty to disclose to the buyer. As a buyer's agent, you disclose everything. Material, not material. That's fiduciary duty. That goes well beyond disclosing material facts. Right. Well, that's a different question. Her question now is, basically, she's a listing agent. Your seller says, well, did you ask your seller to disclose it? And they said no. Or you just took it upon yourself to, I mean, that's a good question. Her scenario would be the seller tells you about this problem, but the seller doesn't plan on disclosing, as far as you know. Should you disclose it anyway? And that's a good question. You have an independent duty to disclose things, but you also have a duty not to disclose things that your client doesn't want you to disclose if they're not material. So you need to have a conversation with the client and say, I think we should disclose. As the client says no, well, they have the right to say to you, don't disclose it. It's not a material fact. My attorney told me it's not a material fact. I don't have to disclose it. Should you put it in writing between you and your client? Depends on how much you trust your client. You can't hurt to do that, yeah. But always call the hotline and get the legal advice as to whether it's a material fact that needs to be disclosed anyway. Right. Yeah. Well, we have a trust advisory, which does explain all this stuff about who's exempt. So I advise you to give that to your clients. Oh, that's different. On the question of who has the right to sell it, that's like I said, that's the trust document. Anytime there's a trust, there's some trust agreement. To enter into a trust, there's a contract where everyone agrees these are the terms of the trust. One of the things in that document says who can sign on behalf of the trust. That's what I'm talking about. Okay? Let me just wrap this up with a... I'm going to condense my 4-hour class into 5 minutes. You ready for this? Just in case any of you weren't in the class or you forgot the class and you know we got the new contract now, the big points are the contract I mentioned about the agency is attached. The contract went from 8 pages to 10 pages. The buyer inspection advisory went from 2 pages to 1. So some of the buyer inspection advisory is now on the contract. The old contract had 30 paragraphs. The new one has 32. All of the paragraphs in the old form are still in the new one. They're 2 new things, brand new. I mentioned them. One of them is when you sign on behalf of someone else, you have to attach an addendum saying, I really am the right person, and within 3 days I will provide proof. That's paragraph 19. The other brand new paragraph is 26 that says this contract is not assignable without the seller's permission. It means all the years you were in real estate before this, halfway through escrow, the buyer could have assigned their offer to somebody else without the seller's permission. Don't you wish you knew that all those years? But it's gone now. So if you want to assign your contract to someone else during escrow, you need the seller's written permission. There's a new form for that. The AOAA, the Assignment of Agreement Addendum. There are only 3 brand new forms that came out a month ago with the new form. That one, and then the other 2 brand new forms are the buyer's demand for release of deposit and the seller's demand for release of deposit, because the contract now says if you want your deposit back and the other side is just stonewalling the escrow company and not responding, you can submit a demand, I want my deposit, and the escrow has to send it to the other side. And if the other side doesn't respond in 10 days, escrow can release the money without a signature. But yeah, it's important, huh? In other words, you're the buyer. You want your money back. You've canceled the deal. You still got your contingencies. You have the right to cancel. You've notified the counsel. You want your money back. Escrow says to the seller, "We need you to sign," and seller ignores them. Doesn't even respond. The contract now says buyer has the right to submit a demand to escrow. Escrow has the duty to send that to the seller, and if the seller just ignores that for 10 days, escrow can release the money without the signature. Of course, a couple of issues here. It does go both ways. If the seller wants the money based on liquidated damages and the buyer just ignores it, escrow can release the money. A couple of issues here. Number one is, if during those 10 days you do respond and say don't give it to them, you got the same problem. The second thing is we have to persuade the escrow companies to do this. So we'll see. Okay, we're working on that. But so the only 3 brand new forms are the agreement to the addendum, the Assignment of Agreement Addendum, AOAA, and the buyer's demand for return of deposit, BDRD, and the seller's demand for return of deposit. The other forms that were changed, I mentioned that the HOA split into 3 forms. The COP form, the make my offer contingent on selling my house first, the bottom of that form used to be where the seller could make their acceptance contingent on finding something to buy. That's now on a separate form. And then the RR split into 2, right? The RR and the RRRR. The RR form. The pirate form, basically, because it used to be the RR had the buyer's request, the seller's response, and the buyer's reply. Now it's the buyer's request and the seller's response, and the buyer's reply is on a different form. That's really the first time you've actually had to use 2 forms to sort of to negotiate something. Because like on the purchase contract, buyer signs, seller signs. On the counteroffer, buyer signs, seller signs. But the request for repair, the buyer would sign one and the seller would sign the other. So you got two forms sort of working together there to do something. So that's sort of a new concept. But it's not really a new form. They just put it on the bottom. So those forms split, 3 brand new forms, purchase 2 brand new paragraphs. I mentioned the disclosures, right? The loan contingency went from 17 to 21 until funding is gone, unless you write it in, right? And there's one new contingency, which is if you're buying a house with leased equipment, your offer is contingent, like solar panels, your offer is contingent on approving that lease. So if you look at the contingency removal form now, it's got 8 contingencies rather than 7 like it had the last 14 years. Right, the buyer could say, I don't know, I can't assume it or I don't want to assume it. It's another way to get out of a deal. And what this is really telling you is, remember, as a buyer's agent, you don't automatically remove all your contingencies on day 17. You have to think about it. The loan contingency is now 21. Well, maybe I didn't get the HOA documents till late, so I have more time for that. Or did you know if you make your offer contingent on selling your house first, you don't have to remove that contingency until your house sells. You don't have to do it on day 17. Some buyer's agents think I have to remove all my contingencies on day 17. That's not true. You have to think about it before you remove any given contingency. And I'm basically done. Thank you very much.